Welcome everyone to the Federal Bar Association Key Tam Sections, the Rounds FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy FCA decisions. I'm Scott Oswald, Programming Chair of the Key Tam section with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, hello.
Hey.
In the last Supreme Court term, you examined the likely lower court impact of two Supreme Court cases, U.S. ex rel. Polanski and U.S. ex rel. Schutte v. SuperValu. Now we have our first Court of Appeals decisions applying each of these. And the first, Tejinder, is out of the 11th Circuit, U.S. ex rel. Carver versus Physicians Pain Specialists of Alabama, in which the 11th Circuit grappled with whether the government met its burden when it sought intervention and dismissal of a long-pending Key Tam action. How did the Carver court come out?
Yeah, I wouldn't really say they grappled with it. This looked like a pretty easy one for the 11th Circuit. They had a relator here who had provided information about overprescribing of opioids, and that actually led to criminal prosecutions of a couple of the doctors involved. And then the relator also filed, had the Key Tam action in place and pursued a default, and then was trying to prove up a default judgment. But the problem was that since none of the defendants had appeared, the relator didn't have that much information about how many claims had been presented, so on and so forth, had a hard time proving damages. So the relator tried to use the criminal restitution numbers as the damages numbers. There were a variety of reasons why that didn't work. The relator propounded all these discovery requests on the government that I think the government found super annoying. Some of them weren't really focused on the damages question, were focused on other issues. And eventually the government got ticked off enough that it decided it wanted to move to dismiss. And it, unlike in some cases where the government's dismissal motion is pretty bare bones, in this case, they provide a fairly detailed explanation of why the relator was just not doing what the relator was supposed to do, why the relator was actually making FCA enforcement harder and not adding anything to the government's efforts in this case. The district court took a look at that and said, okay, I'm going to grant the motion to dismiss. And then in the intervening period, the Polanski decision was decided, which said basically the government has the power to intervene and dismiss, which it did here. And it's subject to the requirements of Rule 41, which were met here because, there were no answers. So there was no restriction really on the government's ability to do this. So this was a very straightforward application of the Polanski standard. It highlights what I think I've always believed, which is that if the government wants your case dismissed, it's probably eventually going to get dismissed. There are one or two counterexamples where cases that the government wanted to dismiss have resulted in a recovery. But I think by and large, and going forward, we'll see more cases like this one, where if the relator gets crosswise with the government and the government seeks dismissal, it will be granted and the grant will be affirmed.
The lesson is don't get crosswise with the government.
That's right. Even if, as here, you have a meritorious case, right? The government thought the conduct here was bad enough to pursue criminal charges and presumably would have also involved FCA liability, but it was just too much fuss. And so they let it go.
Our second case out of the 7th Circuit, U.S. ex rel. Heath versus Wisconsin Bell, Inc. It interprets the scienter requirement of the Federal False Claims Act as articulated by the Supreme Court in Schutte versus SuperValu. Is there anything of note about the author of the Heath opinion?
Yeah, so this opinion is authored by Judge Hamilton, who was also the dissenting judge in the SuperValu and Safeway cases that went up to the Supreme Court. Judge Hamilton has always taken, I think, the view of scienter that the Supreme Court adopted in those cases. And so here he had a chance to take a small victory lap as he discussed scienter in the context of this decision. And
so the court, how did it come out?
So this was a case in which the district court had granted summary judgment to the defendants, and the 7th Circuit reversed and said this case is going forward to trial. And the case actually walks through the elements of falsity, scienter, and materiality, and does a nice sort of greatest hits of the recent appellate decisions and Supreme Court decisions reviewing these elements. And comes out in the relator's favor. The crux of the case is really about whether the relator had shown through expert testimony that the defendants were charging more money to schools and libraries for various telecom services than they should have been. They were required to give these institutions their best prices as a condition of getting government subsidies. And the relator said they weren't doing that. And the relator, I guess, had not done a great job in the district court of showing that other customers who were similarly situated got better deals, because he hadn't focused on whether those customers were similarly situated. But the 11th Circuit kind of picks through the expert report and says, actually, you know, there is enough here to support liability. And then it goes through each of the elements and shows why they're met. On the scienter question, I think the most notable thing is it says, you know, the defendant has made this argument based on our super value decision, that's been reversed, that goes away. There's enough here to show that they were at least reckless. And one of the things that the court points to is the fact that they admitted they knew this rule exists, but they hadn't adopted compliance procedures. And then even after they were rolling out compliance procedures, they were continuing to overcharge. And so it was by virtue of the fact of overcharging alone that the 7th Circuit determined there was sufficient circumstantial evidence of scienter. So this is interesting because it suggests that in a lot of cases under the new standard, you may see the fact of a violation be adequate circumstantial evidence, not only of falsity, but scienter, if they know of the law and they know the legal requirement they're supposed to follow. I think that's a pretty powerful holding for the government and for relators in future cases. There's also a good holding on the materiality side. We haven't talked about Escobar in a long time because that's sort of been settling down. And this reaffirms the consensus. The defendant had said, hey, with materiality, you know, the government knew about these allegations for a long time. It hasn't done anything. And the 7th Circuit says, no, not even close. What you need to show is that they knew of actual violations, not merely knew of allegations. And so the fact that they knew of these allegations and didn't act isn't enough to defeat materiality at summary judgment. And so the case is now going down and going forward for trial.
Finally, we have two cases out of the 9th Circuit to discuss. The first is Hendrix versus JM Manufacturing, which is about both liability and damages in a fraudulent inducement case involving substandard products here, Tejinder. What happened?
Yeah, so this is a case in which various localities brought actions against the manufacturer of municipal water pipes, like the pipes for water mains, alleging that it was manufactured in a way that wasn't compliant with industry standards, contrary to representations that it would be manufactured properly. And the case actually got all the way to trial, and there were two trials, one on liability, which found in favor of the plaintiff, said, yep, this was false, this was material, jury ticked through all the elements. And then there was a trial on damages that actually resulted in a jury deadlock. And then after the deadlock, the district court said, actually, you're not entitled to damages as a matter of law because you haven't shown that the pipe you received was worse in some quantifiable way. That is, you haven't with sufficient specificity established how this pipe is worse, and therefore we can't quantify your damages, so you don't get any damages. The plaintiffs appealed from the damages verdict, and the defendant cross-appealed from the liability verdict. And the 9th Circuit affirmed in all respects. So on the question of liability, it said, no, you are liable because you falsely represented your compliance with these standards. You knew that's what you were doing. And the plaintiffs provided evidence that said that they would not have bought this pipe had they known the truth. Then the court pivoted to damages and said, actually, the district court was correct here as well. You need to be able to quantify your damages in some meaningful way. It's not enough in this context to say, I wouldn't have bought the pipe unless you have returned the pipe or stopped using it, or unless it has failed and caused some real damage. And because there wasn't evidence of that before the 9th Circuit, it said, this is not enough for damages. So this is a case that has a little something for plaintiffs and a little something for defendants. The plaintiffs, I think, should like the liability determination being affirmed and the analysis that goes into that. Defendants, I think, can take some solace from the damages. I don't think the case represents a dramatic change to existing law, but it reinforces some principles that are helpful for each side.
Our last case is Silbersher versus Valeant Pharmaceuticals International. This case deals with our old friend, the public disclosure bar to the False Claims Act. And the court held that while a patent prosecution is a public disclosure channel under the 2010 amendments, the patent challenge proceeding at the PTO is not a public disclosure channel under the 2010 amendments because the U.S. is not a party to Tejinder. You argued this case before
I
the
did.
Ninth Circuit. Tell us about oral argument.
Yeah, so this is a case where it's one of actually 3 cases against different drug manufacturers. And the essence of the allegation is that the drug manufacturers obtained certain patents protecting their name brand drugs by fraud. So they had legitimate patents and they wanted to extend the patent monopoly and keep generic competition out of the market. So they got more patents and they obtained those by fraud. And the defendants in all of these cases have argued that the public disclosure bar bars this action because the information about what they presented to the patent office is on the public record of those patent prosecution proceedings. And they've also argued that in some cases, their patents have been challenged by generic manufacturers. And in those challenges, more information has come out, some of which is cited in the complaints. And so they say, well, the public disclosure bar applies. And there are 2 pieces of this case that are sort of relevant. The first is a kind of technical discussion about what documents are or aren't within the enumerated channels of public disclosure under the 2010 amendments. And I think that unless people are bringing cases about patents specifically, the differences between patent prosecution and patent challenges are not going to be terribly material to people's everyday practices. The second part of this case, which I think is the holding that has broader import, is that the Ninth Circuit says that the public disclosures in this case were not substantially the same as the allegations in the complaint. And the reason that's true, the Ninth Circuit explains, is that the various public disclosures were these sort of very innocuous anodyne facts that were also in different documents here and there, not all together. There was no one place other than the relator's complaint that pulled together the various facts that were publicly disclosed and explained how they gave rise to a reasonable inference of fraud. And so the Ninth Circuit holds that essentially that the disclosure is too vague and attenuated to constitute a qualifying public disclosure. This is a straightforward application of the Ninth Circuit's own prior precedents. A case called Metesky decided in 2016, which first interpreted these amendments. But it is an important holding in the sense that I think some other courts may have looked at cases where public disclosures were also a little bit innocuous and decided, no, that there actually is a disclosure. And that's, of course, what the district court did in this case. And so I think this clarifies the law in the Ninth Circuit in a useful way.
Finally, Tejinder, Senators Grassley, Durbin, Wicker, and Kennedy have reintroduced the False Claims Act Amendments Act. How does this bill differ from the bill the same group of senators introduced in 2021?
The main difference is that there was previously a section governing the standard for government motions to dismiss. I think now the Supreme Court has decided Polanski and clarified the law. There's no more circuit split. Congress didn't feel any need to take further action in that regard. But otherwise, the bill is largely the same. The 2 main substantive sections, one clarifies the materiality standard, establishing that continued government payments will typically not be a reason for finding no materiality if there are other reasons why the government might have continued to make those payments. The second section that's really substantive deals with post-employment retaliation. So it adds it clarifies that former employees are also covered by the retaliation provisions of the False Claims Act. But otherwise, so it's largely the same bill, just with that one difference.
Tejinder, thank you. And thank each of you for joining us for this edition of the Federal Bar Association Ketam Sections, the Rounds, FCA News with Tejinder Singh. See you next time.